workshop on legal metrology, packaged commodities rules. Basically, there are a large number of amendments with the time, and these rules are applicable on all packaged commodities which are sold in India. So we thought that as per the national practice, we should continue different topics regularly. And today we are discussing about the packaged commodities rules. And if you have any suggestion or anything, you kindly let us know what best can be done. So, sir, today the subject is packaged commodities, which are very important for the consumer point of view as well as for the industries to give the declaration of about their product. Before going to start this legal metrology package commodities rules, I would like to request our Joint Secretary, Honorable Joint Secretary, sir, to kindly inaugurate this workshop with his kind words. Sir, please.
Yeah, thank you very much, Ashutosh, and good morning to all participants. The packaged commodity rules and their amendments. This is the topic for the day. It is extremely important subject matter, and there have been a lot of extremely excellent developments and modifications to the rules which have been done by the Legal Metrology Division of Department of Consumer Affairs, and which are applicable for packaged commodities pan India, for every industry, for every consumer, and therefore their importance is to be understood in detail, which is likely to be discussed today. In any case, any packaged commodity, there are large commodities, and the trend of packaging and selling is growing repeatedly in the societies. As we are evolving, we are moving towards being a developed society and a bigger economy. A lot of items are being packed and sold. So earlier, probably when you went, you would have possibly got sugar through maybe a sack, which was sold as an open commodity. It is still sold, but large number of sugar packets are produced and packed, and maybe 1 kg, 2 kg, 5 kg, whatever are the markings allowed as per the Legal Metrology Act, packaged commodity rules, and all other declarations become important to be given there. So this is one important subject. Then the second part of this is extremely important even for the importers. If you are importing an item which is a packaged commodity, be it a mobile phone or anything, what sort of declarations are required in those kind of packaged commodities which are sold? So from electronics to commodities to daily items to packaged commodities like toothpaste and maybe flour and so on and so forth, the legal metrology rules become extremely important. And there are many sections which in the legal metrology package rules which have been amended to make it more convenient and beneficial for the consumers to read and get a better idea about the commodity, the quantities and the prices per unit there, as well as for the industry and the traders to sell it in the country. So we are progressing extremely fast in the area of packaged commodities. Then there are issues about packages containing multiple products and subjects, which have also been addressed recently by our ministry as a policy. So I think these are all very useful even for the manufacturer and the seller, as well as for the trader, importer, and of course the knowledge about these changes should be regularly told to the consumers, and therefore this particular seminar has been arranged. And I would wish that we threadbare discuss what are the latest amendments to the packaged commodity rules and how they are beneficial to both the manufacturers as well as the consumers. And with these words, I hope, Ashutosh, that this seminar will evoke some more questions which will help us in refining our policy and rules further. Thank you very much.
Thank you very much, sir. Thank you very much for your kind words and enlightening what are the issues we are going to discuss today. Sir, actually, we used to have every Saturday this program from 11 to 1, but due to some official exigencies yesterday, we could not organize, and we thought that to maintain the continuity, we can have this program today on Sunday at 11 from 11 to 1. Thank you very much for this holiday and be part of this program. Thank you, sir. Sir, we are going to discuss about this legal metrology package commodities rules. I think my slide is visible to all.
Yes, yes, it is visible.
Thank you very much, sir. Thank you. Sir, the first is National Consumer Helpline number, which everybody should remember. Kindly take a picture of this. So obviously, I will share this presentation to all after the program with the certificates. The National Consumer Helpline number 1915. At any point of time when you feel that there is a problem in any of the consumer related issues, you can call at this number from 8 a.m. to 8 p.m. And also there is a cyber crime helpline number, because now there are a large number of cyber crimes which are happening, which is also very similar, 1915 and 1930. So both of these two numbers are very important, and I would like to share with all the participants. As we are all aware, legal metrology. Legal metrology, since last many years, we are working with this in this field, and most of the participants are also from the legal metrology fraternity. They are the stakeholders. They are knowing that this is basically applying on the measurements and the measuring instruments. Whenever you are taking any measurement, because life starts since morning when we say we will get up at 6 o'clock or 5 o'clock, and after taking a round of 1 kilometer, we'll come back. So everywhere there is a measurement. In the morning, how much water, 1 liter water we are drinking. So, the measurements plays very important role. And unfortunately, in India, we are not very concerned about the measurement. We take them very lightly. Otherwise, for any of the developed country, the measurement plays a very important role, whether it is in the civil life, or it is in the transaction or protection, maybe in medical, maybe in any of the sale or transaction. Everywhere it is very important. The purpose of this legal metrology is to just ensure that whatsoever the measurements or measurements are being taken place, they are correct. They maintain the accuracy and the security responsibility of the legal metrology to maintain it. It also builds a confidence among the traders, industries, and the consumers that what I am taking, it is correct, or what I am giving, it is correct. It also create very good harmonious environment for doing the business, because when we are doing the business, we need that everything should be ethical. We don't want to do anything hanky and panky which creates problem for tomorrow. These weights and measures, if we talk, it is not a subject of today. As we all remember, if we talk about the Indus Valley civilization or the Mohenjo-daro, at that time also, the size of the brick was of the order of 4:2:1. So that means length, breadth, and height. Everything was decided from the period of Mohenjo-daro. Later on, when we come about this this Kautilya time, it was also mentioned that this weighing and measuring or measurement is a summon function, and it has to be continued. It has to be done in a proper way. The state government or the government has to define or has to decide that this particular weight and measure which is used in any transaction or protection is verified and correct. And this at that time, the Kautilya has made a provision that every weight and measure has to be verified after every 6 months. So this was the time when we were going on. Later on in the Mughal period also, it was very crucial, and they were very concerned about the correct measurements. At the time, the units used in SAIR or in terms of gauges, etc., were still used in India. We are still using these units which were used at that time. In the British period also, we see that Britishers made a very important foot pound and second system in the country, and we are having the standards weights of in the units of pond. We have the balances which can measure the pond balance. So, or the Tola and Masha, all these units were used before the freedom of the India. But at the time of when we got free in 1947, immediately after, we came to know that this is very important subject, and we have to be careful when we are dealing with the weights and measures, because they not only make an impact on an individual, but also make an impact on the economy of the country. How the economy basically depends upon it. If the measurement is not correct, the loss is not of a particular consumer, but it actually lost the whole economy, whether you are taking more or giving less. So both ways it was very well considered, and that's why during this in this Lok Sabha decided to have this weights and measures in a proper way, and and this weights and measures subject was placed in the Constitution of India under entry 50 of list 1, which is unit list. It prescribes the establishment of standards of weights and measures, how the weights and measures will be established, how their standards will be established, and it is the responsibility of the union government to maintain the standards. Considering its responsibility, the central government has framed the act, has built up, has established the laboratories, and also providing the standards to the state governments, where the state governments are not able to take their standards or to replace or to buy the standards by their own. Under entry 33E, which is basically in the concurrent list, the weights and measures except establishment is defined. It is specifically or basically talk about the enforcement or the implementation of the provisions of law. When the standards are maintained, how they will be implemented in the country. It speaks about in the concurrent list. Earlier, before this, actually this 33A came in 1976. Before 1976, this 33A was not there, and the weights and measures except establishment of standards was under state list. That was the responsibility of the state government. But in 1976 or during that period, the government thought that we should have these weights and measures enforcement, and the implementation should be the joint responsibility of the state as well as center. And that's why this was brought under the concurrent list. So now it is the responsibility of the union government as well as the state government to maintain the standards as well as to implement and enforce the provisions of weights and measures laws in true spirit. This LM Act, if we talk about the Legal Metrology Act, the people who are actually working since beginning before the Legal Metrology Act, they are aware. Earlier, there were two acts, the Standards of Weights and Measures Act 1976 and the Standards of Weights and Measures Act Enforcement Act 1985. These were the two acts which were working at that time before the implementation of Legal Metrology Act 2009. This Legal Metrology Act got the assent of the Honorable President of India on 13th January 2010 and came into force from 1st of April 2011 after repealing of these two acts which were at that time in force. If you see the name of the Act, Weights and Measures Act in Britain is also the same. Standards of Weights and Measures Act 1972 of the UK in United Kingdom. So similarly, we were having the provisions, and these 1976 and the 1985 acts were very beautifully drafted. All the provisions were complete in themselves. There was no need to refer the other acts or the other provisions of the acts. But when we brought this new act, the Legal Metrology Act 2009, we were having a single act, unified act, which has basically replaced both of these two acts. It is a very simple act which has only very few sections, only 57 sections, which enforces, which implements the complete provisions of the Legal Metrology Act as are available in any one of the developed countries in the world. We are having all the provisions. We are the member of the international organization, and we are working accordingly as per the recommendations made by the international bodies. The objective of this Legal Metrology Act is to establish and enforce the standards of weights and measures. What will be the standard of a weighing or measuring instrument? How a weight and measure will be manufactured? What will be its requirement? What will be its specification, and what will be its verification? All are comes under this standards of weights and measures. It is to regulate weights and measures in the trade and commerce in weights and measures, because anything which is being sold, it will be either through weight or measure or number, and other goods which are sold or distributed by weight, measure or number. So this act basically establishes and enforces all the provisions of weights and measures, how it will be implemented in the country. Obviously, this Department of Consumer Affairs is the nodal agency for the implementation of the Legal Metrology Act 2009. As we know, this Legal Metrology Act, when it came in 2009, earlier to that, the penal provisions or the compounding offenses, compounding fees were very small because these were decided in 1976. And when we brought this 2009 Act, the penal provisions were enhanced. Standardization of units of weights and measures was based on metric system. It also provides the declaration on prepackaged commodities. It also provides that all the weighing and measuring instruments which are manufactured or sold in India, they have to be approved by the government, by the central government before manufacturing or import. It also prohibit for manufacturing, repairing or sale of any weight and measure if a person does not have the license from the state government. The controllers of the legal methodology of state governments used to issue a license for manufacturing, selling or repairing a weight or measure. Every weight and measure has to be verified and is stamped by the legal metrology officers before putting into use or before sale. This is also provided under Section 24 and 33 of the Legal Metrology Act that all the weights and measures has to be verified before putting into use. And you will be surprised to know that we have crores of instruments available in the country which are all verified and stamped by the legal metrology officers of the state government as per their duration, maybe 1 year, maybe 2 years, or maybe 5 years. This also has a provision. Before this act, there was no provision, and all the directors of a company used to be booked for any violation or an offense under the act, or basically, I should say, any omission of any of the provision of the act. In the now under this 2009 act, we have made a provision that the companies can nominate one of their director who will be actually responsible for any offense or for any wrongdoing or for any omission or for any error in the implementation or in the use of the act. Also, this act provides that for any establishment or or a unit of a company, different persons can be nominated. We have already made this provision under the nomination procedure. Similarly, there is also a provision for verification of weights and measures. Because we have large number of weights and measures, the private government approved test centers can also be developed, can also be approved for verifying the weights and measures, to just share the responsibility of the state governments in the field of verification of weights and measures, because the number is very high. If we talk about the units of weights and measures, the units of weights and measures, all units are as per the metric system. We have the metric system already. India is a meter convention country. India has signed its meter convention in 1957, and as per the meter convention treaty, we are complying, or we are actually allowing in India only the MKS system or the metric system of the units of weights and measures. For example, the length will be in length will be in meter, mass will be in kg, time will be in seconds, electric current will be in ampere, temperature will be in Kelvin, luminous intensity will be in candela, and amount of substance will be in mole. These are all defined under this act. How they will be determined, how they will be capped, how the realization of these units will be as per the international standards. It all defined under the legal methodology, national standards, rules, and the act. Actually, before this November 28, 2018, when we actually the CGPM, the General Conference on Weights and Measures, decided in November 2018 that all the units, international system of units, will be on the basis of the natural constants or fundamental constants of nature. Before that, the units, in case of the mass, there was a platinum iridium. As we are all aware, there was a crystal of platinum iridium like this, as we have seen in this is a national standard kept at National Physical Laboratory, New Delhi. And basically, there was a platinum iridium crystal which was placed at Paris, and we were taking it as 1 kg. This was an artifact, and all the 1 kg which were given to all over the world, all the countries which were the member of BIPM, International Bureau of Weights and Measures, they were having their 1 kg unit with them, and they used to compare it after every 10 years with the international standard. But in 2018, November 2018, where India was also there to vote in favor of changing the units from artifacts to natural constants or the fundamental constants. This came into force from 20th May 2019, and now all the units will be derived or will be taken, the SI units will be traceable to SI units. This is basically the natural constants. Recently, in November last year, this BIPM has decided, because the units of 10 raised to the power 27 and 30 were not defined, that how they will be represented. Now, we have already decided that for the multiplying factor of 10 raised to the power 27, the prefix will be Rona and symbol will be capital R. For minus 27, it will be Ronto, small r. Plus 30, it will be Qto, capital Q, and minus 30, it will be Qto, which is small q. So this is the way how we have added these four. This means, because with the development of these with the development of this atomic or up to the smallest level of mass and the highest level of mass or highest level of units in the terms of distance and all, we have to have 10 raised to the power 27 and 10 raised to the power 30, because these were units. These units were used earlier, but they were not internationally accepted. The BIPM recently in last year has also decided there's 27, minus 27, 30 and minus 30, both of the units will be, both of the suffix or multiples will be given like this. As we have for the small unit ml, milliliter. For higher units, we use kg or tons and like that. Similarly, this will, and kg may be 10 to the power 3 grams, tons will be 10 to the power 6, like this, or seconds, nanoseconds, milliseconds, or microseconds. Similarly, all these units will be in terms of 10 raised to the power plus or minus. May in both of the directions they can move, they can be represented. The international system of units, basically SI system, this was after the revision of these systems. If we see the SI system, the natural constant of this for this kilogram is the Planck's constant H, which the value is also given over here 6.6 and into 10 to the power minus 34 joule seconds. And this meter will be the speed of light c, time. Second will be the frequency of the hyperfine cesium atom, delta nu. Current is ampere, which is the electronic charge of an electron, 1.6 into 10 raised to the power minus 19 coulombs. Kelvin, which is the temperature, K, and again it will be defined in terms of Boltzmann constant. Kelvin Boltzmann constant is small, okay, and this Boltzmann constant's value is also defined 1.3 into 10 raised to the power 22 joule Kelvin. Mole is Avogadro number, that is Na, and its value is also defined 6.022 into 10 raised to the power 23 per mole. Luminous intensity candela, which is KCD, and its value is 638 lumen per watt. So all of these units are already defined under by 2019, and they came into force from May 2019. So this is the way how all the units under this legal methodology are defined. As we are all aware, we are the member of International Organization of Legal Metrology. It was established in 1955. Its headquarters is at Paris, and we are the member of this OML since 1956. Even India signed its metric convention in 1957. However, we signed or we became the member of International Organization of Legal Metrology in 1956, because we were aware that for any of the international trade, we have to be the member of OIML. How our standards can be traceable to the international standards, how our weighing, how our measuring will be capable or will be traceable to the internationally. This was only done through this International Organization of Legal Metrology. The purpose of this International Organization of Legal Metrology is to promote the global harmonization. It harmonizes the national laws and the regulations on performance of measuring instruments. It is very interesting that all the weighing and measuring instruments which are tested anywhere in the world, they are mostly as per the International Organization of Legal Metrology recommendations. In India also, we are completely, more or less, we are taking the OML recommendations, and our testing, our test report, our formats are as per the OML recommendations. Even any of the laboratory which is doing the testing and calibration of weights, balances, or any of the equipment which is related with the legal methodology, they are all doing as per the OIML recommendations. It facilitates international commerce of measuring instruments and affected products. It ensures quality measurements for public and worker health and safety and protection of environment. It harmonizes national procedures for testing and verifying the performance of measuring instruments. So these are the basically importance of harmonization or the promoting the global harmonization of legal metrology. This legal metrology OML, how it supports it, the benefits of harmonization are it increases the international trade. When we will be having the internet, we will see if our standards are traceable to the international standards, then whatsoever the weighing we are doing in India, whatsoever the measuring we are doing in India, that will be equivalent to all over the world within its tolerance limit. It also reduces the cost for manufacturers, because if the standards are not correct, measurements are not correct, the loss of the commodity, the loss of the raw material will be more, and we can reduce with the help of the standards measurements. The products which are manufactured with the help of these standards or the measurements are the quality products, which are basically for the measurements for society. It impacts on consumers, national and international trade, all industries, manufacturers, etc. We are participating in all OML meetings. We are the CIML member. We are having participating in all meetings, and basically we are voting for we are voting for all the recommendations or the standards made recommended or framed by the legal methodology OIML. India basically votes in all these committees. The next target for the legal methodology is we have to have the electric vehicle charging rules, so that we can ensure that how much is the charging is being done, it is correct or not. We have to have the rules for hydrogen cars, LNG trucks, gas meters, energy meters, moisture meter, because moisture is also very important for the food grains and all. And in India we are having the moisture meters, but they are neither calibrated nor tested, so we have to bring them under the we have to make the rules for them, and so that these units, these equipments can be ensured they are actually as per the international standards. Sound level meters, taxis using GPS, radar equipment for speed of vehicles, EEG, ECG, etc. This is basically required for sale, for documentary standards, all we need for the legal methodology. If we talk some of the important definitions under the Act, it defines the protection and the transaction. The Legal Methodology Act and rules are applicable on all type of protection and transactions. Protection is nothing. Protection basically speaks if we are using a weighing or measuring instrument, the readings of that weighing or measuring equipment, if in any case affects the protection of a human being or an animal or a commodity or a vegetation or a thing, individually or collectively, that equipment will be the part or will come under the provisions of the legal methodology. So basically the units we are taking on a person weighing machine, on the basis of this person weighing machine, we are defining that whether the weight of a person is increasing or decreasing, whether it is in a hospital or in a hotel or at our homes. We should know whether the machine is correct or not. And considering all this, we are basically not only testing before approving the model, but also the verification and stamping of the legal methodology is necessary on all type of person weighing machines, even for thermometers, blood pressure meters. They are used for the protection of an human being or an animal. If we talk about the well-being of any commodity, if we are using a weighing or measuring instrument which prescribes the readings of that instrument, prescribes the well-being or the protection of the commodity, then it will also cover. For example, if you are manufacturing medicines in a factory, in a pharma factory, and this particular weight or measure is not verified, or the flow meter is not verified and stamped, not necessary that how much constituent, a particular constituent has to be mixed or has to be made or has to be included in a particular drug, whether it is correct or not. It may not, it may, in place of giving the correct results, it may simply it may harm the protection of a human being or an animal. So everywhere where we feel that the readings of an instrument somewhere affecting the protection of an animal or a human or a vegetation or a thing, we need this this equipment has to be verified and stamped and comply the provisions of the legal methodology. Transaction basically defines whenever it may be any contract for sale, purchase, exchange, or any other purpose, any assessment of royalty, toll, duty, or other dues, or the assessment of any work done, wages due, or services rendered. Wherever we see that any of the transaction which covers under these definitions, under these provisions, it will be covered under the legal methodology. The weight and measure or the weighing or measuring instrument has to comply all the provisions of the legal methodology act and the rules made thereunder. I hope that this transaction and the protection does not leave any of the equipment which will not need to be verified and stamped, or which will not be requiring the approval or the other requirements of the law. Seal and stamp is also defined, that we need to have the sealing of any weighing, sealing of every weighing and measuring instrument before, to ensure that it cannot be tampered or it cannot be simply fraudulent use. Stamp is a mark made by impressing, casting, engraving, etching, branding, affixing pre-stressed paper seal or any other process in relation to any weight or measure with a view to certifying that such weight or measure conforms to the standard specified by or under the act. It is very important whenever we are sealing an equipment, it is giving a security, it is giving a guarantee that this weight and measure is correct. And that's why a seal wire, with the help of a stamp, we have the punches, with the help of the punches we used to stamp. But again, there is a problem whether this lead should be continued. Again, there is the lead creates a lot of problem, and it is not a good element for the environment. So what to do? Even we have introduced paper seals and other provisions. Even after in India we are using the lead seals, we have to think what other we can do. Sorry, verification. Verification is also very important term, because under the legal methodology, calibration and verification, these are the two things. In calibration, basically we are just telling the true value or the correct value of a weighing and measuring instrument, whether it is this weight, how much value of this weight is. Let's say it is 1 kg, whether it is 1 kg, less than 1 kg, or with plus 1 kg. We are just giving the value. But in case of verification, we are not only doing the calibration, but also we used to try to bring it within its error limits, because under the legal methodology, the errors are defined, prescribed with uncertainty also. We used to calculate the uncertainty also. And whether this particular equipment or particular weight or measure is within the uncertainty limit or within the error or not, we have to ensure that if it is not within the error, then it will not be used, it will be rejected. So in verification, basically calibration, re-verification, everything comes into it, and it is nothing, it is just the process of comparing, checking, testing, or adjusting any weight or measure with a view to ensure that such weight or measure is complying the standards established by the act. Label we used to put on all prepackaged commodities, or to just give us the basic information about the product, when it was manufactured, or what is the MRP, who has manufactured, and what is the inside the commodity, how much it is. So all these information, we need a label may be written, marked, stamped, printed, or graphic matter affixed to or appearing upon any prepackaged commodity like shown over here. Under the Legal Metrology Act, we have framed these 7 rules. These 7 rules are framed by the Government of India, Union Government. And apart from these central rules, we have the enforcement rule of each and every state. Every state has framed its own enforcement rule on the basis of the model rule, which was circulated by the Union Government to all the state governments to frame according to that models to have the uniformity in the whole country. However, few of the provisions are within the power of the state government to frame the rules for those provisions, and the state governments are free to frame their rules as per their requirement. These rules framed by the central government are general rules. In the general rule, as its name feel, it is not a general rule, but it prescribes the standards which are required for any weighing and measuring instrument. How a weighing and measuring instrument will be manufactured, will be tested, and how it will be represented in the market, or how it will be, what declarations it should have. All things are defined under the general rules. It is a very important rule in which all type of weighing and measuring instruments are defined. Apart from this, it also prescribed what will be the periodicity of the verification of a weight and measure and other provisions of weighing and measuring instruments. The next is packaged commodities rules. These rules are also very important, packaged commodities rules, because they prescribe what should be the declaration, how a declaration will be made, and what we have to declare on a prepackaged commodities. All these things comes under this packaged commodities rules. We have another rule which is approval of model rules. In case of these legal metrology, we have framed the approval of models. Any weighing and measuring instruments, as we are all aware, under Section 22, it has to be approved by the Union government before manufacturing and import. It basically ensures that the weighing and measuring instruments which is being manufactured or imported in our country is complying the provisions of the required the specifications as per the rules or not. These are manufactured as per the international standards or not. For all these things, these weighing and measuring instruments used to be tested before manufacturing or import. We have another rule which is national standards rules. National standards rules are very important for the scientific and the technical community, as well as for the students of the engineering and the medical, etc. In these rules, we have defined how the national standards will be framed, what is the traceability, what is the hierarchy, how much will be their period of verification, and where they will be maintained, how they will be manufactured, where they will be manufactured, with all the standard units and their values. For example, the Planck's constant is defined and given the value over there. The Boltzmann constant is defined, given the value over there. So all the scientific and the technical units are given under these national standards rules. As we are aware, since May 2019, we have replaced the base units, the definitions of base units of all these seven base units: mass, kilogram, mass, and mass, length, time, temperature, etc. And the new units have already been prescribed under the national standards rules in 2019 itself. We have already made the amendment that what will be the new units of all these base units. What will be the new definitions of all these base units? We have already decided, we have already notified. So we are all working as per the international standards, and we have also requested the schools and colleges that now in the syllabus of this, in the schools of and the colleges, these new definitions used to be taught, so that the children should understand what is the new requirement. We have the numeration rules. Numeration rules also prescribe how a numeration will be written. What will be the representation of writing a numeration? As in India, we used to write thousand, lakhs, then crores, then Arabs, like that. In Hindi, we used to use these units. That means the first unit is three zeros, then two zeros, two zeros, two zeros, like that. This is the way how we used to write in India, and after the decimal we use two zeros. So this is the Indian notation which is accepted. Similar at the same time, internationally we used to write in terms of three zeros: thousands, million, billion, like that, trillion, like that. So 10 is about 3 million, 6 billion, trillion, 9. So like this, we used to put all these units in terms of in the numeration values, how we will represent. Both of the units and both of the ways of representation are allowed as per the in legal metrology numeration rules 2011. Even when we stop this use of the coin, small coin like 25 paisa, the old people, the young children do not know. Earlier we were having 25 paisa coin also, even 5 paisa coin also. The old people have seen the 5 paisa when we used to buy a toffee of 5 paisa only, a long time back, maybe 45 years or 50 years back. So, but the new children, even they have not seen the 25 paisa. So this 25 paisa was recently discontinued in 2020, in 2011 or 2010 and 11, in between that, when we allowed that this may be discontinued. See, we another have the Indian Institute of Legal Metrology Rules 2011. These rules prescribes the establishment of an institute which is at Ranchi for the training of legal metrology, and this is one of the best institute in this area, in Asia, we should say. And we used to get large number of foreign trainees for getting trained in legal metrology in India. This training institute provide the training to large number of industries, to large number of institutions in India, and every year large number of people are being trained under this for this legal metrology over here. So this is one of the best institute, I will say, in India we have for the legal metrology purpose, training of legal metrology purpose. We have also these government approved test center rules. These government approved test center rules rules basically prescribe how a government approved test center will be established, what it will verify, how it will verify, and what will be the rules to implement the provisions of this section 24 of the Legal Metrology Act, which prescribe the notification of a legal metrology government approved test center. Fortunately, we have few of the government approved test center like the regional reference standards laboratories working in India. They are all GATCs, government approved test center. They are doing the verification of weights and measures with the state governments. State governments are having the primary responsibility of verification of all weights and measures used in any transaction or protection. With them, with the state governments, the regional reference standards laboratories established by the union government are also doing the work of verification wherever required. If we talk about the pre-packaged commodity is very important, and all be aware that nowadays most of the commodities are sold in the pre-packaged form because it is very easy. Just a package is placed, you just have to give an order and take the package. It is very easy. Earlier, when this rush was not there about 40 years back, we used to buy most of the products, many of the products in terms of the loose form or the open form, but all are now available in terms of the packaged commodity. It is good also. Section 2L of the Legal Metrology Act defines the prepackaged commodity, according to which a commodity which, without the purchaser being present, is placed in a package of whatever nature. If you are placing a product in a package when the purchaser was not present, this will be known as a prepackaged commodity. This product, this package may be sealed or not. It may be sealed or open. Any type of package may be there, so that the product contained therein has a predetermined quantity. I say that inside this particular package, whether it is sealed or not, 1 kg, 1 liter, 100 gram, or one number is placed in a package, it will be considered as a pre-packaged commodity, because when this was packed, whether sealed or not, was the consumer or the purchaser was not present. Section 2F provides the definition of label. We have already discussed it. Section 18.1, it provides the declarations on prepackaged commodity and restricts manufacturing, packing, selling, importing, distributing of prepackaged commodities unless they conform to prescribed declarations. Under the packaged commodities rules, we have prescribed the declarations. What declarations have to be given on a prepackaged commodity? If these declarations are not mentioned on a prepackaged commodity, it should not be packed, sale, or import if it is not complying the provisions of law. Section 18.2 provides that advertisement, any of the advertisement which is mentioning the retail sale price, that is the product or the price of this particular commodity is, let's say, 100 rupees, then it must have the quantity. How much is the quantity of that package for which the cost is rupees 100? So these sections prescribes where we need these sections basically prescribes what is actually required to sell a prepackaged commodity. Section 36 prescribes the penal provisions. As we are all aware, under the Legal Metrology Act, the penal provisions are also made if there is not the compliance of any of the provision of the Legal Metrology Act or the rules. Section 36(1) prescribes for the declaration part. It speaks that the selling, manufacturing, packing, importing, distributing, delivery, or otherwise transferring, offering, exposing, or possessing for sale any prepackaged commodity which does not conform to the declarations of the packages. If the declaration is required and it is not given, MRP, net quantity, anything, if it is not given on this prepackaged commodity, then the offense or the violation can be compounded by giving a fine of rupees 25,000 rupees. And as it is fine, see, the fine has to be basically, many times we consider that it has to be trialed and then only it can be paid. But under this Legal Metrology Act, the beauty of this Legal Metrology Act is that the fine can be compounded at the department level itself. We don't have to go into the court of law, and we don't have to basically make a person guilty over there. If any of the notice is issued and the person or that company agrees that there is some omission by or an error in declaring any of the part or the point which was not given, they can compound the first offense by paying a rupees of 25,000 rupees in the to the government treasury, government account. For second offense, it can be compounded by a fine, paying a fine of rupees 50,000. However, for subsequent offense, fine will be more than 50,000 rupees, but it may be up to 1 lakh, or it may be the imprisonment up to 1 year if the offense is continuously being done, or the person or the company is a habitual offender of a particular offense, because this may be done once for the first time or second time or third time. But this can be compounded under section 48. It should be very clear to all. There is no need to be trialed in the court of law. It can be compounded at the department level by the controller, director, or the legal metrology officer authorized by the director or the controller. It can be compounded at the department level. Even it is given the word fine, because we have mentioned in the subject it is penalty. Section 36(2) prescribes, there may be large number of questions. Certainly, we will take immediately after this program. We will be having some of the photographs, and then we will discuss the question answer session. Whatsoever you want to ask, you can ask. There is no problem. So we will allow all of you to speak one by one. Selling, manufacturing, packing, importing with error in net quantity. It is very important, because a small error of, let's say, some grams in kgs will affect the large number of consumers, and the loss will be very high. This is called economic loss. Maybe a consumer who is getting 5 or 10 gram less, it is not very, very important, or I should say, it is not harming the consumer or an individual consumer in a big way, but economically the loss is very high, and that's why the class suits and other cases are being booked against the companies when we found that there is an error in the net quantity. For the first offense, again, it is compounded. It can be compounded at the department level. The compounding fee may be 10,000 rupees to 50,000 rupees. And for the second and subsequent offense, the provision is for the compounding by paying the fine, or with the imprisonment, or with both. So there is a provision made under the law that first offense in all the cases, first violation in all the cases can be compounded. And if an offense is done after 3 years, it will be deemed as the first offense. So basically, we consider that an inadvertent error may happen, and if an inadvertent error happened, the compounding may be done so that the company should not face any type of problem, and easily it can be sorted out. Rule 2H of the packaged commodities rules provide that how the principal display panel will be given. Because under this legal metrology rules, packaged commodities rules, we ask that the declarations should be given on the principal display panel. And it should be very clear to all of us that principal display panel is not a particular area where the declarations have to be given. Let's say if it is a product, the whole surface area of all the sites, including this, all this is called the principal display panel, number one. But when we are calculating the size of the numerals and the letters or the words, we only take the bigger side, this side and this side only for the principal display panel. Principal display panel means the total surface area of the package, whole area, surface area of the package, where the information required under these rules are to be given. The declaration can be given at any place on this principal display panel, and the whole surface area we termed as the principal display panel. It should be given, all the information could be grouped together and given at one place. It is very much required. Otherwise, it is very difficult that one declaration is at one side, at another declaration is at another place, and the person is regularly only just looking, the consumer is looking all the sides to see where the declaration is given. So it is very necessary, as per the rules, that all the information could be grouped together and given at one place, or the pre-printed information could be grouped together and given in one place, and all inline or online information grouped together in other place. So that means only at two places the information can be given. One is at one place where all the information is grouped, which is pre-printed, and the another is online, which can also be grouped together at another place. So at two places the information can be given or declared on a pre-packaged commodity as per the principal display panel. But not more than two. And if all the information is pre-printed information, it has to be given at one place only. If the information is scattered here and there, it will be the violation of these rules, and certainly the case will be booked. So the request to all the industries is all the information should be given, should be grouped together and must be given at one place. If it is online and pre-printed information, it may be given at two places. Under these legal metrology package commodities rules, there are some declarations which have to be given on all pre-packaged commodities. What are these declarations? If we see, these are very few, and I think that it is not very complicated or anything which is confidential, which the industry would not like to give. It is general information. What about the name and address of the manufacturer, packer, or importer who has manufactured or packed or imported? Let's say I'm not the manufacturer, I am just a marketer. So the name of the marketer should be given. Like that, we can consider name of the and address of the manufacturer, packer, and importer, country of origin if imported. If a product is imported in the country, then the country of origin is very much required, from which country it has been imported. And it is also requested not to give the abbreviation of the name of the country, but you should be given the complete name of the country, like PRC, People's Republic of China, Province Republic of China, we should give the complete name. Common or generic name of the commodity. It is also very important that what is the commodity which is packed inside the package, whether it is water, whether it is flour, whether it is a pulse, or whatsoever it is, tea, coffee, etc. The name of the commodity has to be given, which is the generic name. Net quantity should be in terms of standard units of weights and measures or number of commodity in the package. It is very much required. We all consider only the MCAS system, as we are the meter convention signed country, or we have already adopted the meter conventions. So the standard units of weights and measures in SI system has to be given, which is kilogram, gram, meter, seconds, liter, milliliter, etc. It should not be like in terms of gallon or in terms of gill or in terms of pound, ounce, like that. These units are not allowed under the legal metrology package commodities rules. They have to be given in the standard units of weight and measure. MRP, which is inclusive of all taxes, as we are all aware, this MRP is inclusive of all taxes. We used to get the information that few of the companies are selling their products, and after giving the discount of, let's say, 50%, they are after giving the discount, they are adding the GST. How it is possible? When you have discounted, the next price will be the MRP. So it is the discount is being given by you only. Whether the cost of the product is 100 rupees, in place of giving 50% discount, you simply say that its cost, we are reducing only 32%, and it's simply we are reducing it, let's say 41%, and its cost is, let's say, 49. My request is kindly silent the mobile. So this is very much required. The unit sale, this MRP has to be given in terms of the Indian currency. It is also mentioned in the rules that it will be given in the Indian currency, because we only understand the symbol rupees or RS. What is it? Another very important amendment was made in 2021, 2nd of November 2021, about the declaration of unit sale price. Unit sale price basically defines the cost of a unit, maybe a gram, maybe ml, or maybe one number. Like that, this unit sale price was defined, and it was supposed to come from April 2022, but on the request of the industries, we have given the time till 1st of April 2023. It was supposed to implement from 1st of April 2022, but now it has been extended till 1st of April 2023. And we think that from 1st of April, because industries have already started, and even the industry can start from now itself, they can declare the unit sale price, and most of the industries are already giving it. Most of the industries are already declaring it. But my request will be to all the industries to declare this unit sale price before 1st of April, so that there should not be any problem after the implementation of this provision. Next is month and year of manufacture. Earlier, the provision is month and year of manufacture or pre-packing or import. The provision is still working, that you can give that month and year of manufacturing or packing or importing. But from this 1st of April 2023, we are expecting that there will be only the declaration of month and year of manufacture Prepack or import we have deleted from this 2nd of November 2021, as this provision has not been implemented. That's why this is not a violation, or an industry is giving either manufacture or prepacking or import is allowed. But my request will be, as we have to do it from 1st of April, if we start earlier to that and we can only give the month and year of manufacture, then it will be very good before the 1st of April. The rules also requires the declaration of best before or use by date, month and year. Best before, up to which date it can be used, or use by date, month and year. It is very much required in case of the commodities which are becoming unfit for human consumption with the passage of time. So this provision is basically for those commodities which are becoming unfit. But as we are all aware, this particular thing was with the trucks, cosmetics, and the food products which are actually consumed by us. So, and I hope that all these declarations are already mandatory under the Food Safety and Standards Act and Drugs and Cosmetics Act. So it is not affecting a lot. Sizes, dimension, and we have already also given a provision that if you are declaring already this best before use by date under any other provision of law, then it will be continued. This will not be implemented. However, any of the commodity which is used for human consumption, we will have to see whether the use by date or best before date, month and year is given or not, as per the packaged commodities rules. Sizes, dimensions of the commodity if relevant. If dimensions of different pieces are different, then dimensions of each such different piece has to be declared on the prepackaged commodities. Again, it is also very much required. Many times we should know what is the size of a towel which is packed. Let's say 6 towels of different sizes are packed in a package, and we are just buying as a single commodity. We should know what is the size of that product. Consumer care details, it is again because we want that if there is a dispute, if there is a problem, if with any of the consumer, this consumer should directly talk with the manufacturer or the supplier and can resolve his issue. That's why it is requested, it is asked, or it is being made mandatory for every prepackaged commodity to declare the consumer care details. In consumer care details, they have to mention their name and address and the phone number, email ID, etc., so that the consumer can directly contact with the manufacturer or the packer to resolve his issue. There are the provisions made under the legal metrology packaged commodities rules for the e-commerce entities. As we are all aware, before that, and we are expecting that more than 50% of the market is going towards the e-digital or e-commerce sites. So we have to be careful when we are giving the orders and we are receiving the products on e-commerce sites. These rules are applicable from 1st of January 2018, and they are all in force. These rules requires an e-commerce entity to declare the name and address of the manufacturer, importer, or packer, etc., who has basically who has manufactured, packed, or imported the prepackaged commodity. Name and address of the manufacturer or importer, country of origin if imported, common or generic name of commodity, net quantity in the standard unit of weight, measure, or number of commodity in the package, MRP inclusive of all taxes, best before or use by date, month and year in case of a commodity becoming unfit for human consumption with time. So these are the very basic information which we are asking from an e-commerce entity to be given on its website, because as the consumer will get the product, he will get all this information printed or available declared on the prepackaged commodity. However, before deciding what he has to purchase from an e-commerce site, he should have this basic information available with him. And this is not very much, this is very few information which we are asking: name and address of the manufacturer or importer, country of origin, common or generic name, net quantity, MRP, best before, use by date. As we have already decided that this e-commerce entity has to give these declarations under this rule 610 of the packaged commodities rules, this provision is made for the declaration on e-commerce sites. Now, a very important point is size of declarations under packaged commodities rules. As we are all aware, it depends upon the area of principal display panel in square centimeters. And what will be the area of principal display panel which will be considered to decide the minimum height of numerals and letters? Minimum height of numerals and letters which are declared on the prepackaged commodity. This size, this area will not cover most of the things. For example, if I just take, this is a bottle, in this bottle, this size, this neck will not be considered, will not be taken as for the principal display panel. Only this circumference will be considered height into this circumference, this complete surface area will be considered as the principal display panel. So there are many other things which will be considered for deciding the principal display panel. For a rectangular box, we used to take the four sides of the rectangular box of a prepackaged commodity like this whole surface area for the prepackaged commodity. So if the area, the whole surface area of a prepackaged commodity is less than 50 square centimeters, then the minimum height will be 1 mm if it is printed, and if it is molded, blown, formed on the surface, then it will be 2 mm. For the area of principal display panel, if it is less than 100, then it will be 1.5 and 3. If it is in between 100 and 500 millimeters square centimeter, then the size which will be printed on the principal display panel will be 2.5, and for molded or blown, it will be 4 mm. If the area of the principal display panel is in between 500 and 2500, the size of the letters and numerals will be 4 mm and 6 mm respectively. For the principal display panels more than 2500 square centimeters, this size will be 6 mm and 6 mm in both the cases. So the purpose of this particular provision is to ensure that the size of the numerals and the letters are clearly readable or easily readable by a consumer. And up to some this 1 mm size, it is very small. However, considering the size of the package, this 1 mm has been prescribed. This is a very important rule. There should not be any confusion when we are making a declaration on a prepackaged commodity that what should be the size of the letter or numeral, height of the letter or numeral in millimeters for on a prepackaged commodity. There are few important provisions. Rule 18.2 provides that no retail dealer or other person, including manufacturer, packer, importer, and wholesale dealer, shall make any sale of any commodity in packed form at a price exceeding the retail sale price thereof. It is very important. I think that when it is free to decide the price, MRP. MRP is prescribed or decided by the manufacturer or the importer himself. We do not play any role in it. We are only having the declaration mechanism that it has to be declared. What is the price? But once declared, it has to be honored. No product should be sold over and above the MRP. However, it is observed from the experiences or in the markets that many times the sale of the product is over and above MRP. And we used to get the complaints, we used to get the information. How to control it? It is very difficult. The state governments used to take action. They used to issue notices. They used to compound the offense. However, many times it is observed that the MRP is more than the MRP declared on a prepackaged commodity, or the selling price is more than that, which should be which has to be considered. And I would like to request all the industries to kindly adhere what is declared by you. Rule 18.2a prescribes that unless otherwise specifically provided under any other law, no manufacturer or packer or importer shall declare different MRPs on an identical prepackaged commodity. If there are two identical prepackaged commodities, let's say water bottle of 500 ml or 1 liter each, one is available at one place and another is at Y place, the prices both of these two bottles should be the same. This is again a requirement of the law. Shall not declare different MRPs on an identical prepackaged commodity by adopting restrictive trade practices or unfair trade practices as defined under clause 41 and 47 of section 2 of the Consumer Protection Act 2019. This should be considered, this should be taken care of, and we are already implemented it. Rule 18.5, no wholesale dealer or retail dealer or other person shall obliterate, smudge, or alter the retail sale price. It is again very important thing that once declared, the price has to be honored. We have declared that this much is the retail sale price. It has to be honored till this product is available in the market. It has not to be changed its price once declared. We should be very clear about it. Again, under the legal metrology package commodities rules, rule that is 27 requires that all these package commodities manufacturers, packers, and the importers has to be registered with the controller of the legal metrology or the director of the legal metrology, so that whenever required, we can check the declarations and the net quantity at their factory premises or the premises where the products are stored. And there should not be any problem in the market. We should not be restrict ourselves to check the net quantity in the market, which is very difficult and cannot be completed without a great help. This registration can be done online. All the process is online. The fees is only 500 rupees, and after the starting of the work, you can do this registration within 90 days from the date of on which or it commences such packing. It is the website is nsws.gov.in. You can go through it, this website, and can get the registration of a manufacturer, packer, or importer. Again, very important thing which we used to understand, what will be the maximum permissible errors on net quantities declared by weight or by volume. See, when we are packing a prepackaged commodity, certainly there should be some errors or some tolerances should be allowed in the packages. For example, this is either in gram or ml, and the maximum permissible error may be in excess or in deficiency. There are two ways: by the percentage, as percentage of the declared quantity, or directly in terms of gram or ml. For example, if the declared quantity is up to 100 gram, up to 50 gram or 50 ml, the net quantity is 5%. The net quantity, the error or the tolerance in the net quantity is 9%. 15 to 9% becomes 4.5. That means up to 4.5 gram, the error, maybe plus or minus, may happen with an individual package. But it does not mean that all the packages will be packed in less than 4.5 gram. It is for an individual package, and the law allows how much is the error allowed as per the package quantity. Because when we check the net quantity at the factory level, or we are taking the either 32 samples or the 80 samples like that, in that case, the average is always accurate, that is 50 gram. However, an individual package, due to the tear and wear of the machines, due to the technological problems, may have the variation up to 9% in case the declared quantity is 50 gram. 9% error is allowed. From 50 gram to 100 ml, 50 gram to 100 gram, or 50 ml to 100 ml, the error allowed is 4.5 gram. It means up to 100 gram. From 50 gram, as we have already seen, up to 50 gram, the error allowed was 9%. 9% is 4.5 gram for 50 gram. But if it is, let's say, 10 gram, in case of 10 gram, the error allowed is 9%. 10 gram, 9% becomes 0.9. 0.9 gram error may be allowed, which is less than 1 gram, in case of a package of 10 gram. Similarly, if the package is from 50 gram to 100 gram, the error allowed is only 4.5 gram. From 100 gram to 200 gram, error allowed is only 4.5%. So again, if it is, let's say, 100 gram, the error allowed is 4.5 gram, which was in the last case. But for 200 gram, the error allowed is 9 gram. So up to 9 gram or 9 ml, in case of a package of 200 gram, individual package I'm talking, not the average package or all the sample package, up to individual package, in an individual package for 200 gram, it is allowed is 9 gram. Similarly, from 200 to 300 gram, it is again 9 gram. From 300 gram to 500 gram, it is 3%. That becomes 9 gram to 15 gram. From 500 gram to 1000 gram, that is up to 1 kg. From 500 gram to 1 kg, up to 1 kg, error allowed is 15 gram. From 1 kg to 10 kg, it is again 1.5%. That means 15 gram and 150 gram. 150 gram error is allowed. From 10,000, that means 10 kg to 15 kg. The error allowed is 150 gram. For example, if we just consider it, for if we take this example, then in case of the LPG cylinder is value is 14.9 kg, 40.2 kg. So this will fall under this category, and the error allowed is 150 gram. Up to this 150 gram error, it is allowed. For the packages packing more than 15 kg, the error allowed is 1%. 1% means again 15 kg 150 gram, 20 kg 200 gram, 30 kg 300 gram, like that. It is in terms of percentage. So this is the table which prescribe, and this table is not being made by us in India. It is an international practice, and as per the international practice, these accuracies, these tolerances, these errors are allowed in the prepackaged commodities when we are going to check the net quantity at the factory premises or in the at the industry level. Sorry. So this table is an international practice, and these tolerances are allowed internationally. How much will be the error or the tolerance which will not be considered to book a case is this much for different sizes of the prepackaged commodities. If we talk about the recent amendments, it is again a very important thing, and I think that we should discuss it. Rule 2AA, it was amended to incorporate the new Consumer Protection Act 2019. It is not very important. Rule 4, amended to insert sub-rule 2 for promotional offer, which was earlier provided under Rule 5. Actually, we have the Rule 5 was linked or was related with the second schedule, which was prescribing the sizes of 19 commodities. From this 2021 notification of 2nd November by GSR 779E, we have omitted the second schedule. When we have omitted the second schedule, this Rule 5 was not required, and the provision of promotional offer, we have put it in the Rule 4, and Rule 5 is now omitted from 2nd of November 2021. However, due to the extended period, it is not enforced, and till 1st of April, 31st of March 2023, industries can continue to either omit or to continue that rule, because the law provides if you are complying the provisions of this 2021 notification, there will be no case booked against the company. The second schedule has been omitted with effect from 20th March, by this notification 28th March 2022. However, again, as I discussed, you may continue. Rule 61D, again, it has been extended since till 31st of March 2023. Rule 61E, it talks about the MRP is the maximum retail price inclusive of all taxes in Indian currency. Obviously, it has been given in the Indian currency in terms of rupees only, not in terms of pound, ounce, or dollar, etc. The provision of unit sale price was introduced under Rule 16, 611, wide 779E on 2nd of November 2021. However, it was further amended in 28th March 2022, wide notification of 226E. What is this unit sale price? Yeah, the unit sale price in rupees. It will be given in rupees only. Obviously, we are giving you the prices in rupees in India, rounded off to the nearest two decimal places. It is also very important when we are giving the unit sale price that it may come in the decimal parts up to a large number, and it will never be ended. But we have to declare in terms of only two decimal places. Shall be declared on every prepackaged commodities in the following manner: per gram where net quantity is less than 1 kg. If you are packing a net quantity in a package which is less than 1 kg, then the unit sale price will be in terms of 1 gram per centimeter, or when the net quantity is less than 1 meter. And similarly, if the quantity is more than 1 kg, it will be in terms of 1 kg per kilogram. If it is more than 1 meter, it will be in terms of 1 meter per milliliter for less than 1 liter, and in terms of liter when the net quantity is more than 1 liter. So it is very simple. Up to 1 kg, it will be in terms of 1 gram. Above 1 kg, it will be in terms of 1 kg. Up to 1 centimeter, it will be up to less than 1 centimeter, if it will be per centimeter. And from above 1 meter, it will be in terms of meter. So 1 meter. Similarly, per milliliter, if it is less than 1 liter, and above 1 liter, it will be in terms of per liter. It is very simple to decide or to prescribe or to declare on the prepackaged commodity. Within the bracket, you can declare, you can put USP, anything if you want, per number or unit if the item is sold by number or unit. However, there are two provisos, provided that for packages containing alcoholic beverages or spirituous liquor, the state excise laws and the rules made thereunder shall be applicable within the state in which it is manufactured. So for alcoholic beverages, this unit sale price is not required. Provided further that declaration of unit sale price is not required for the prepackaged commodities in which retail sale price is equal to the unit sale price. For example, we are saying that MRP is for, let's say MRP is 1 liter, for one MRP is for 1 liter. In that case, the unit sale price is not required. 1 meter, not required. 1 liter, not required. 1 kg, not required. So when the unit sale price and the retail sale price both are equal, in that case, the unit sale price is not required to be declared. This is very important, the unit sale price, and it will solve our problem of reducing or after omitting this second schedule, because after the omission of the second schedule, the commodities can be packed in any quantity, and to safeguard the interest of consumer, it is very important that the consumer should know which is cheaper and which is costlier. As now we will be getting the prepackaged commodities. Earlier, let's say it was 1 kg, or let's say 900 gram. Now it may be 920 gram, 912 gram, 896 gram, 890 gram, like that. So it will be very difficult for a consumer for a particular commodity to compare the prices. And that's why it is decided that all the commodities should be given with the unit sale price, and consumer can easily compare the prices of two similar products. Rule 1352, which was amended for declaration of net quantity in number, it provides that the items sold by number, the number or unit or piece or pair or set or such other words which represents the quantity in the package, one pair of socks, one pair of shoes, one piece of this. So like that, which is very similar, and the consumer can understand. Earlier it was necessary to mention one N or one U. Even you can continue with one N or one U. It is also clear that it is one unit or one number. So one N or one U, which the industries were declaring earlier, it is also allowed. Any type of similar words are allowed, and there should not be any small, many times the industry can put one set of shoes, one pair of socks, like that. And there were, as these words were not allowed under the rules, there were the notices or the cases booked against the industries. To sort out this problem, we have allowed that any such type of word which makes the clear representation of the commodity can be allowed. We have also amended Rule 18.2a to incorporate the provision of New Consumer Protection Act. Rule 18.7 was amended to mention the VAT or TOT, turnover tax. Now it is only given the GST, as all goods and services tax has been introduced, and now there is no other type of tax. So we have removed this, and now we only have the GST. Rule 32 is also omitted, because as the second schedule has been omitted, there cannot be any need of allowing or giving the permission for non-standard size, because the industry is now free to pack in any of the size as per the requirement of the market or as per the requirement of their industry. It is also given the permission that no prosecution against the manufacturer, packer, or importer for declaring with effect from 1st April 2022 is, if as per the amendment, will be made against the manufacturers if they are implementing these provisions before that. Even now, you can implement any of the provision. There will be no violation against the industry. These are the few amendments which we have made recently. Under Rule 6, it has been inserted for a period of 1 year in some rules or clauses for electronic products. Basically, the electronic industry was facing some problems when the size of the product is very small to give all the declarations of the package, and it is only given for the electronic products, considering that the consumer which is entering at the shops of electronic products, he will be having this facility, or he will be provided this facility to read the scan or read or scan the barcodes. Under Rule 1A, it has been allowed to declare the name of the manufacturer, packer, or importer on the package. The name of the manufacturer, packer, or importer has to be given on the package itself, and the package will inform to scan the QR code for the address and other related information. Address is not given on the package. Address is not printed, or it is allowed within the law, as per the law, that address can be given through the QR code. However, name has to be given of the manufacturer, packer, importer has to be given on the package itself. This particular package will inform to scan the QR code for the common or generic name of the commodity. What is the common name of the commodity or the generic name of the commodity? Where such package contains more than one product, then for the name and our number or quantity of each product has to be scanned. It has to be given, or it can be scanned through the QR code. Inform to scan the QR code for the size and dimension of the commodity, and this package will declare the telephone number and email address on the package itself, and inform to scan the QR code for other related information. For other informations, we can only scan the QR code. In case such information is declared through the QR code and not declared on the package itself. So this rule provides that declaration can be given as we are already giving on the package itself, or these few informations can be given through the QR code. But this package will inform that this information is available in the QR code, and you can just read through the QR code, and the facility of reading the QR code through the smart meter, through the smartphone, or through the barcode reader has to be provided at the shop itself. But it does not protect or restrict a manufacturer, packer, or importer to declare this information on the package itself. Either you can declare on the package, and if you feel that there is a problem to declare on the package, you can give through the QR code, but this information, that the particular information is through the QR code, has to be given on the package itself. तो कहने का मतलब क्या हुआ कि जो आपका पैकेज है, यदि उसके ऊपर हमारे कुछ डिक्लेरेशंस क्यूआर कोड के थ्रू दिए गए हैं तो वो अलाउड है, यदि आप पैकेज पर नहीं देते हैं और क्यूआर कोड के थ्रू देते हैं। लेकिन ये इंफॉर्मेशन देना जरूरी है कि ये पर्टिकुलर इंफॉर्मेशन क्यूआर कोड के थ्रू दी गई है, और वहां पर हमें क्यूआर कोड को रीड करने की फैसिलिटी भी देनी पड़ेगी। ये थोड़ी सी हमारी इंफॉर्मेशन है जो हमने दी है। ये दूसरा अमेंडमेंट हमने किया फॉर द गारमेंट और द हाइजरी सोल्ड इन लूज और ओपन फॉर्म. These are also exempted from the packaged commodities rules at the point of sale if consumer can inspect the products before buying. These products are exempted, and only the very few declarations have to be given on these open or loose sold garments or the hosiery items. Name and address of the manufacturer or marketer or brand owner or importer with country of origin or manufacturer in case of imported products. If the product is manufactured in India, you just have to declare the name and address of manufacturer or marketer or brand owner or importer. Consumer care email ID and phone number. Sizes with internationally recognizable size indicators such as S, M, L, XL, XSL, XXXL, etc., along with their notation in metric system, centimeter or meter. Maximum retail price, inclusive of all taxes in Indian currency. Exemption shall apply to sale of finished products only. The above information shall be displayed on e-commerce website if sold through e-commerce also. Any manufacturer, packer, importer may declare the above information with immediate effect. This was also allowed. Actually, this rule was supposed to come from 1st of January as it was made in August. And at that time, it was decided that if an industry wished to declare this information with immediate effect, they can do that. But from 1st of January, it has been made mandatory. This is another amendment which is also very important, made on 4th of October. It also provides that Section 49 of Legal Metrology Act allows the companies to nominate any of its directors as a person responsible for the business of the company. This act allows, Section 49 allows. However, on the interest of industries, on the request of the industry, this has been allowed because as per the Section 49, it has also allowed that for different units or establishment, different persons can be nominated. So this has been, earlier it was considered that only the director will be nominated, but the rule was amended, Rule 29 was amended, and it has been allowed for the companies to have, which have different establishment or branches or different units in any establishment branch, to nominate an officer who has the authority and responsibility. But the officer to whom you are nominating should have the authority and responsibility for planning, directing, and controlling the activities of the establishment or branch or your different units. It is very important. हमने कहा कि डायरेक्टर के अलावा यदि किसी कंपनी के पास बहुत सारे एस्टेब्लिशमेंट और यूनिट हैं तो वहां पर दूसरे लोगों को आप नॉमिनेट कर सकते हैं. मैनेजर हो सकता है, जनरल मैनेजर हो सकता है, एनी वन ऑफ द इन वेरी सीनियर ऑफिसर कैन बी डन. बट लेकिन जो ऑफिसर आप नॉमिनेट कर रहे हैं उसके पास प्लान करने की, डायरेक्ट करने की और कंट्रोल करने की एक्टिविटीज को पावर होनी चाहिए, अथॉरिटी होनी चाहिए और रेस्पॉन्सिबिलिटी भी होनी चाहिए उस पर्टिकुलर एस्टेब्लिशमेंट या ब्रांच के लिए. तो इस तरीके से ताकि जो आपका लीगल मेट्रोलॉजी का रिक्वायरमेंट है वो भी फुलफिल होता रहे, साथ में जो डायरेक्टर्स को हम छोटे बहुत सारी चीजों के लिए नोटिस जाते थे वो भी कम हो जाए, उनको भी हम हटा सकें. यही पर्पस था इसका. Fourth schedule of packaged commodities rules. It is also very important for the declaration of net quantity on edible oil, etc., in volume without temperature. Without temperature. So what it basically speaks, the first direction was issued on 15th of July 2022, and it was expected that this direction will come into force from 15th of January, 2023. But on the request of the industries, it has again been deferred for 6 more months, and now this direction will come into force from 20th of January, from 15th of January 2020, 15th of January 15th of July 2023. Now this direction was issued on 20th January 2023, by which this particular direction now will come into force from 15th of July 2023. What it asks? Actually, the net quantity of an non-edible oil, vegetable oil, edible oil, and vanaspati ghee, etc., should be declared in volume or weight. The second schedule provides that if the declaration is in terms of volume, then it must be declared in mass also, because the volume, which we all know, is depending upon the temperature. However, the mass remains always constant. So if the declaration is given in volume, then it will be given in mass also. And if you are declaring it in mass, then there is no need to give it in volume. You can declare only in mass also if you require. But that if the quantity is in terms of volume, then mass has to be given. Earlier, what was happening, that the industries were declaring this mass with volume, and volume was 1 liter, but at a particular temperature. And it was observed that volume remaining constant 1 liter, mass was reducing as the temperature was increasing from 30 degrees Celsius, 40 degrees Celsius, 50 degrees Celsius, 60, 65 degrees Celsius, like that. So it was decided that it may be a chance of cheating of the consumers. It was decided that the volume will be declared without specifying a particular temperature on the package of edible oil, which may cause cheating to consumers. Now it has been extended up to 14th of July 2023. Now, state governments under these directions have been requested to create awareness among the manufacturers, packers, and importers of edible oil, etc., to pack the commodity without mentioning temperature, and to advise them to ensure that the quantity declared on the package in volume or mass is correct. The manufacturers, packers, and importers are advised to correct their labeling of declaring net quantity in terms of volume within 6 months from the date of their direction, which will now come from 15th of July 2023, without mentioning the temperature. The field officers have been advised accordingly. So the purpose of this particular direction is to declare the net quantity, if it is declared in volume, is without temperature. The purpose is only to maintain the temperature, to maintain the quantity which is actually uniform throughout the industry. Otherwise, if one industry is giving 900 gram and the another is giving 910 gram, consumer is cheated by giving 900 grams. Secondly, there is a big loss to the economy of 10 gram in every package. If the packages are sold, lakhs of the packages are being produced in a day, then there will be a big economic loss. And considering that, this direction was issued, but on the request of the industry, because there was large number of packaging material available with them, it was decided to extend for 6 months, 6 more months. But I hope that most of the industries have already started that, and maybe within a month or so, all the industries will be complying this provision. However, time is more. But when the product will be used, or when this all available product packaging material will be exhausted, the industry will start using the new provision. Few advisories were also issued to e-commerce sites. All the e-commerce entities have been requested to prominently display all mandatory information required under the package commodities rules at one place. It is very much required, as we are asking on the package, but on the website, if we are declaring, we are just searching one declaration here and there, it is very difficult for any of the consumer. And we have requested that kindly prominently display all the information at one place, because it is also required on the package in case of the package commodity. Declaration of foreign country name mandated under the law, and it should be in full form and no abbreviation or shortened form whatsoever should be used. Make a provision on the e-commerce websites so that sellers should not be able to upload their products if all the mandatory information are not displayed by them. It should be very clear that if their product is not clearly, if the declarations are not made properly, then this product should not be uploaded. For non-compliance of provisions of Act and rules for prepackaged commodities under Section 1836 and Rule 6 of PCR, many notices have been issued to the manufacturers, etc., and we are asking them to either compound the offence, but many of the cases have already been placed in the court of law, and obviously the courts will issue the summons if the cases are not compounded at the department level. For non-compliance of weighing and measuring instruments like Section 19, 22, 23, 24, and Rule 6 of packaged commodities rules, again notices have been issued. Few of them have been compounded, and others we are finding in the court of law, because now the court will decide what punishment has to be given, whether it can be left with one case, because we see if we are doing it, we are just complying the law, and we are taking the compounding fee which is already prescribed under the law. We are not doing anything else. We are not asking, we don't have the power to either reduce or enhance the fine, enhance the penalty or the compounding fee. But court has a power. They can reduce, increase, send the jail, whatsoever they can do, they will do. But my request to all the industries, wherever there is a notice, it is always requested to kindly compound the offense, so that we and you will not be fighting in the court of law, where a lot of other things will also be coming into the picture, like how much is the tax you have paid, how much was the verification fees, how much you have done, and where is the lacking. So we need that this can be compounded at the department level. This is a request to all. One very few slides I would like to discuss. We have the one is the Indian Institute of Legal Metrology, Ranchi, which is providing the training to all the participants, and also we have the 7 regional reference standards laboratories which are functioning at different geographical regions in the country. At 5 geographical regions we have at Ahmedabad, Bangalore, Bhubaneswar, Faridabad, and Guwahati. Similarly, 2 new RSS, one is at Varanasi and one is at Nagpur, are under establishment. These laboratories basically doing the work of verification, calibration, and testing of the state governments, and functioning for different purposes. They are doing the verification of legal standards. They are basically a link between the National Physical Laboratory, and they are basically maintaining a traceability chain from international standards to the traders level. And we just want that all the weighing and measuring instruments should be traceable. These are the functions. These are the facilities of testing of all type of weighing and measuring instruments. We have mass, balance, volume, dimension, hydrometer, temperature, pressure, test sieves, force, load cell and torque. Load cell facilities we have. Flow, water, and flow we have the mass flow meters, as well as the for water meter also. We have the procedure for tank calibration. So these are the few things which we are doing at these laboratories. This is the only discussion which I wanted to make with all the participants. Thank you very much for your patience hearing. Thank you. Yes. Now, Santosh ji.
Sir. Yes, sir.
my request will be you kindly take the photos of the participants first,
Okay.
and then we will discuss the questions. We'll take the questions also, questions. In the meantime, you please do the make them
Okay.
the
Okay.
panelist and then take the photos. Sir, there are a few folk. Dikshit Sab is also here. Sir, would you like to say something? Dikshit Sab?
This is a very good lectures given by you, and it was basically only on the legal metrology act and the rules, and nothing more than that. जो है.
Yes.
And I hope that all the consumers are satisfied by getting the net quantity, and our loss is made only for the proper check of the net quantity, and consumers may get the correct quantities. And at the international level, when the transactions are being made, then also it will be fair to get the correct quantity and provide the peoples to also get the correct quantities. So this is the main objective of our law, and we are the member of OIML. So wherever there is a need of the industries, and the this general rules should be modernized, and what will be advantage that by the um, amendment in the general rule, that you will get the better technologies, and what are the better technologies are coming, and that will be also checked properly, because if you are not modernizing, amending the law, so the better technologies are coming in India, so they are getting the lot of safeguard, and the consumers may be cheated, and we are not aware also. So this is the things. Otherwise, everything is correct, and we should continue such seminars and discussions so that we may exchange the better knowledge, and we should give opportunity to speak the industries also, so that we may get their views also. Being suppose we are having 2 hours or 3 hours time, so 30 minutes time should be given to the industries. One lecture of the industries, any industries. So if there is a good speaker, that should be selected from Deputy Director RSL's Sri Ashutosh Agarwal and Saab, and he is also the in charge Director Legal Metrology, and that will be very good things. Yes, any question?
Yes, I have a
Very well, sir. We have few
Huh?
questions. Yes, sir.
Hmm.
We are just taking few questions. We have in the chat box. No different MRPs should be for two identical packages. My request is kindly put your question in the chat box. We'll take one by one because otherwise it will be difficult to speak all the people. My request is kindly put your question in the chat box. Sir, one question is no different MRPs should be for two identical packages, but if same MRP is declared for two unidentical packages, allowed. Very good question. Basically, we are talking that there should not be two different MRPs on a single package, and it's a different thing that the industries are giving the price of, let's say, 150 gram and 140 gram, as the example is given, having one is at the shop and the one other is at e-commerce. At e-commerce 140 gram and in the shop it is 150 gram. We have to check whether this 140 gram quantity was declared on the website or not, on the e-commerce site or not, and if it was given, then the law is very clear that there should not be two different MRPs on an identical prepackaged commodity. We have to see it how we can maintain or how we can bring it, how we can enforce it. Certainly is a good input, but my request to all will be, you kindly let us know that whether the participant who has given this question, request will be kindly send me either in my WhatsApp or in mail that whether it was declared on the website or not. Thank you. Next is online procedure for nomination under LMA. Yes, very clear to all. I am just putting this on the chat box. lm.doka.nic.in. This is the request to all. Please kindly switch on the video to all the participants. Switch off your mic. Switch off your mic. There are some noises. Yes. So the portal is lm.doca.nic.in, and anybody can put an application for the nomination of director on this website. Can you please explain what is the definition of loose items? If we buy loose garment from outlet of any brand, whether it is loose, see, it is very clearly defined over there in the law itself, in the rules itself, which can be checked or which can be basically feel or which can be touched, which can be seen at the shop, at the retail outlet point. It will not be considered as a package. It will be considered as a loose garment. In the definition, it was mentioned. What is the definition of, yes, loose item? It is the same. If a manufacturer does not mention the manufacturing address, consumer care details on their product, then how someone or customer can complain, and where to complain? Kindly answer. Very good question. See, if you are getting a particular product without declaring the name and address of manufacturer or the customer care details, you are aware, you know that from where you have buy that product, and you can inform the local legal metrology officer or to the central government or to the controller of the legal metrology that this product I have procured, I have purchased, I have buy from this particular shop, but nothing is mentioned over there. So the shopkeeper who has purchased, who must be aware where he has taken this product. It is necessary to mention unit sale price next to MRP for per unit. See, this is very clear that all the declarations should be given at one place. Again, to request to kindly switch on your videos, because we are taking the pictures for the YouTube, for our Twitter handle as well as YouTube as well as video to be placed on the YouTube channel. My request will be that this picture will be, we are putting on at LMGOI, our Twitter handle. Kindly like it. Your own photo, you should like your own photo. You must like your own photo. So if the question is, if the manufacturer is not giving the address, etc., you kindly inform us, and when we will ask with the seller, we will come to know where the product was. He has bought this product. Yeah, next to MRP or not. So next to MRP it is not necessary as per the law. All the declarations pre-printed at one place and online at one place, or if the all declarations are pre-printed, they are online, they have to give in at one place. But it is not necessary that it should be with this or with that. It should be, but it is obviously convenient for everybody, even for the manufacturer also, to declare the MRP, and with the MRP to declare the unit sale price. Is there any schedule from where the generic name or common names of the product is to be taken? It is the responsibility of the manufacturer. He knows better. Why we should make that this should be name of this only? The manufacturer or the importer or the packer should be given this liberty. The consumer should understand what is the product inside that particular package. Sorry. Is it required to mention unit sale price on e-commerce sites? Very good point. Actually, the unit sale price we have asked under sub rule 11 of rule 6, and this e-commerce sites rule is sub rule 10 of rule 6, which only ask to give the declarations required under sub rule 1 of rule 6. So this unit sale price is not mandatorily to be asked on the e-commerce sites until unless these rules will be amended, and that will also be asked under rule 610. We will see. This is a very good idea, and we should also ask the unit sale price on the e-commerce sites. It's a good idea. ऊपर क्यों चला जाता है आगे?
Ashutosh, there is one question on the question and answer portal also.
Okay. Yes.
400-gram product, any product with two MRPs for two different states like AP and Tamil Nadu. Somebody has asked this, Mr. Chandu.
Sir, actually, what we are asking that there should not be two MRPs. But when we see where they are being sold in different states, like we can see a very simple example of the bread when we use in the market. There are always mentioned on the bread that for, let's say it is manufactured in Delhi. Delhi price is, let's say, 10 rupees, and Haryana or UP it is 11 rupees. Like that we have seen. So it's a basically up to some extent very difficult, and we will come back. We have to examine it properly and as per the law, as well as the practical aspect. Then only it will be easy, or it will be good to reply. But we have seen that in some cases the MRP of one state is, let's say, 10 rupees, and in another state it is 11 rupees, considering some transportation cost and all. The individual packet weight accuracy is to be as per the table explained. But what about the whole lot? See, lot we are not selling. See, as far as lot is concerned, it should be when we are actually it is being done in the factory premises or the import places, and it should be accurate. If the average is let's say the packages of 100 gram, the average of all packages should be 100 gram or more. It should not be less than that. It is not allowed. The error is allowed in individual packages, considering the tear and wear of the machines and the technicality of the machine. How to trace, mention date of manufacture for imported product while the product is manufactured bulk. It's not bulk or whatsoever it is not basically required. All the declarations should be given at one place or maximum at two places. We have already cleared. If it is not mentioned at one place, you kindly let us know. We will issue the notice and we will ask the industry to kindly give it at one place. They will give it because they are all aware and they are giving. MRP label state name. State name means manufacturer name only. This is not anything which is MRP label. We are asking the state. We are asking the name and address of the manufacturer or packer or the importer. Industries uses various balances in its premises which are not used to control weight of final pack. Is it mandatory to do verification of these balances by legal metrology officers? Very good question. We have already explained under the term transaction and protection. If you can justify that it is not used for any transaction or protection, then it is not required. But again, you have to say it is in between the local legal metrology officer and the industry that to explain or to understand that it is not used for any transaction or protection. If a package which contains more than one product, is it necessary to declare all the mandatory declarations in each product separately along with the declaration on the outer package? Yes, when you are packing two products, obviously the consumer should know what is inside the package, and the individual packages should also have, because they must be having all the declarations with them. It is mandatory. Manufacturing state is Gujarat and warehouse in Maharashtra. If MH LM officer query on state. See, basically manufacturing state in Maharashtra and warehouse. So obviously you will declare the manufacturing state, not the warehouse. Warehouse is nowhere required. Warehouse is a place where you are just storing to transport, to make it easy, your transportation to supply the product easily. It is observed that manufacturer cleverly make changes in minor grams in net quantity and other side raises MRP at a larger extent. Kindly suggest remedy. See, as this is for this purpose, we have already declared that you mentioned the unit sale price, and after the declaration of unit sale price, this problem will itself be sorted out. When the product is manufactured in one country and packed in another country, what is to be mentioned as country of origin, packed or manufactured? Basically, we ask for the manufacturing, manufactured or assembled. Generally, we ask. So you can declare it the manufactured. It will be easy or better. different between stamping and calibration of weight balance. Basically, calibration, we just say that how much is the accuracy. But when we talk about the verification, we say that it is within the tolerance range, or the verification ensures the readings of that particular weight or the balance are within the limit. It can be used. Is it necessary to write unit sale price as declaration prefix before the value? Nowhere it is mentioned that you have to mention, but it should be very clear that what is declared. We are not asking that you have to write unit sale price or USP. Simply you can put in the bracket, let's say the MRP is 100 rupees for, let's say, 100 gram. Net quantity is 100 gram, MRP is 100 rupees. What you can do within this 100 rupees, you can just put a bracket and with a rupees symbol or rupees, rupees 1 per gram. It will clear itself that it is a unit sale price. So it should be clear what we are declaring. But you declare the unit sale price prefix is nowhere necessary. No different MRPs should be for two identical packages. But sir, if same MRP is declared for, yes, we have already seen. Kindly let me know again what was mentioned on the website. What is the difference between dimension and size in reference to legal Metrology Act? Very good. See, we have asked that the size or the dimension, basically we can say meaning is more or less same. However, again, we'll go through it. I'll go through it, and then what is the technical meaning, I'll come back. AP and TN we have seen. Is it mandatory to keep a weighing instrument at shop counter in cinemas? See, it is as per the law. If you are selling a prepackaged commodity and you are covered under this GST or TOT, whatsoever it is, then you have to maintain. Can we sell a product having a same brand name along with new as prefix for different FDI? See, this is maybe as per the FDI. Legal metrology is not concerned, so I may not be the right person to reply. Whether brand oblique product name such as 50-inch ultra wide brand name TV is within the purview. No, inch is not allowed, whether it is purview or not. You have to mention it in the standard units. It is very clear. We are not allowed to even speak the non-standard units. Why do we not mention the date of manufacturing on the e-commerce platform as per law? Actually, it was given that the products are constantly changing, and that's why it was allowed that not necessary to mention. But however, expiry or the best before date is required for the products which becomes unfit for the human consumption. If in case of different person is nominated for different establishment location, then director would also require to compound the matter, or only company and that nominated officer would require to compound. Very good legal point. We'll again come back. My request is those points which we are not replying now, kindly prepare an email and send it to me with reference to this whole rule, that what the rule asks and what we have to do, so that we can actually examine legally and can come back to all of you. For imported products, it is little difficult to get actual manufacturing date. So it is okay to put date of manufacturing. Manufacturing date is the right word. Date of manufacturing or manufacturing date, it is the same thing. Can we manufacture a product with advanced manufacturing date and keep in our warehouse? How you can do that? Advanced manufacturing date only it is allowed as per the rules when the packaging material of that month is utilized and the next month packaging material you want to use. That is as per the rule. Date of import, no, it is not allowed. After this, you have to mention only the month and year of manufacture. You can say on this presentation, don't different prices on same product. When even place changes, please reply. Okay, yeah, this has to be examined, but again, it's a good question and we observed it is happening. Can online printing information be given at the bottom? Yes, wherever, all the size or every place, any size of this product, wherever it is, you can place, because all this is the principal display panel. When industry do inkjet printing on package, is it considered blown? No, inkjet printing is printing only, online printing. I hope, but legally what you consider, you can do that. When two product manufactured in India and one is imported and we are complying the law of India. So if we want package in one, then any approval needed? Two product manufacturers, that means you are selling three products Why to need the approval? There is no need of any approval. You can sell this. You just need a registration of the packaged commodity. Not required. Most of hotels and restaurants charge more than MRP on packaged water bottle. Is it offense? Actually, as per the Honorable Supreme Court decision and order in 2018, it was allowed that they can sell over and above MRP. So we are not taking any action. Yes, I will share the presentation. Share certainly. Santoshi, when you will issue the certificate, I am sharing this presentation right now to you. You kindly share this with the certificates to all.
Okay, most probably Tuesday or Wednesday.
Thank you. If someone mentioned best before in place, use by or expiry, yes, it is allowed. Now mention best before date or use by date. It is allowed. In a package which contains more than one product, is it necessary to declare all the mandatory declaration in each product separately along with the declaration on the outer package? Yes, obviously it is mandatory. MRP prices mentioned, then unit sale price is not necessary. 1N, okay, yes. If the MRP, it is only one number, then there is obviously not required, but it is not mentioned. So we have to take care of it. Can we manufacture a product with advance? No, it's already done. With identical products like soft drinks bottles, like Coke sold at high price in cinema. No, it's not allowed. Selling over and above MRP in cinema halls is not allowed. It is illegal practice and we can take action. Why identical products like these cinema? Yeah, okay, the same question. Go, yes, presentation share. It is observed, yes. In case of allowed for mentioning the size, for example, 10 centimeter, 10 centimeter, anyone, any format. This is not necessary that you have to do like star or cross. You can do it. It is very easy. Multiple printed net quantity and price respectively, and mentioning it in tick mark with help of marker. Is it acceptable? Multiple printed net quantity. No, it is not so. It will be very difficult because I have not seen a package in which the price, different prices are ticked. I have never seen a package. So why to make the complication for the consumer? Let it be single. If it is observed that some shopkeeper purchase shoes, chappals in bulk on a lesser price, all right, thereafter they pack and put a very high MRP. Kindly suggest remedy. Very good. So basically, who is packing or who is not packing? MRP declaration is important under the packaged commodities, but the declaration or the fixing of MRP or the price is the prerogative of the manufacturer or the packer. If some industry having multiple printed net quantity, and no, this is not for online e-commerce site for products that can originate from multiple countries, all countries of origin can be mentioned. Actual country of origin will be available. So assembling maybe you are doing, or if you are on e-commerce sites for yes, it can be given. We have already discussed at any surface you can give the declaration. So with this, I would like to thank all of you, the respected Joint Secretary sir, respected Dikshit sir, and all the participants for this arts workshop and the seminar to discuss about the importance of the legal metrology package commodities rules. Sir, we are thankful to you on Sunday and Saturdays. We are taking your help on for these programs. Thank you very much. Next week, Saturday, we'll meet with the next topic. Thank you, sir. Thank you very much. Thank you all.
Thank